If you've sued someone because they've wrongfully taken property from the probate estate, you may believe that simply getting that amount back isn't enough. And you may be right. In this video, I'm going to discuss how you can get double damages against somebody who's wrongfully taken probate estate property. In this video, I'm discussing how to prove double damages, what the standard of proof is for double damages, and finally, how to correctly calculate double damages. The first way of proving double damages is by proving a person in bad faith has wrongfully taken, concealed, or disposed of property that belongs to the probate estate. Now, in practice, this is most often used against either the executor or the administrator because we're talking about somebody who's actually taken probate estate property. Once the estate's open, the only person who should have the ability to get access to estate property is the executor or the administrator. So, for example, if you're able to prove that the executor or administrator simply took a whole bunch of money from an estate-owned bank account, then that's going to be a showing that they did this, they had no right to the money, presumptively they've done it in bad faith. Second way of proving double damages is by proving that in bad faith, a person wrongfully took, concealed, or disposed of estate property through the use of undue influence. Now that's a little bit of a mouthful and it may sound like a bit of a mind bender because we're talking about using undue influence to somehow get estate property. So the most likely way this is going to crop up is that there's somebody who is actually able to take advantage of the executor or administrator in order to get the estate property. Now notice, just like in the first way I told you about, you have to prove bad faith here as well. The third way of proving double damages is by proving in bad faith a person wrongfully took, disposed, or concealed of estate property through the use of elder financial abuse. Now, this is meaningfully different from the first two ways I told you about because this means that the taking happened while your loved one was still alive. Financial elder abuse only applies to people who are 65 years or older. So what this really means in practice is while your loved one was alive and they were over 65, there's somebody else who in bad faith wrongfully took or somehow manipulated them into giving them their property that they had no right to. It's important that you understand that however you go about proving double damages, you have to prove that this taking was done in bad faith. And I'm emphasizing this because bad faith is a high standard of proof to be met. Now, oftentimes in these cases, once you actually get into discovery and you're able to dig up the real facts, you have a very clear case of what has gone on because frankly, there is no good explanation for how the property went either from your loved one while they were alive or from the probate estate after death to somebody else who paid nothing in return for what they received. Where you've got that kind of crystal clear evidence, you've got an awfully good chance of proving bad faith. But in fairness, not every case is that clear cut. Some cases are a lot more muddled and it may become clear somewhere along the way that you're not going to be able to prove bad faith. It's okay. If you're able to prove this wrongful taking, you're still entitled to damages or the recovery of the property, whatever the case may be. I don't want you to think because you don't have perfect proof that you don't have a case. You still have a case. You're still either entitled to damages or return of the property. You just may not get double damages in addition to that. Oftentimes people want to know, does double damages mean I get twice the damages that I typically would, or does that mean I get twice as much in addition to the damages I otherwise get, meaning I get triple damages altogether? I wish there were a clear answer in California, but right now there isn't, and here's why. There's one appellate court that decided this issue by saying what double damages means is whatever your damages order is, you double it, that's what you get. So it's 2 times what you would normally get. 3 other appellate courts that have heard this have decided differently. They've all said you get double damages in addition to your regular damages, meaning you get triple damages altogether. So you need to know this because where this case gets filed may have an impact on what the total damages will be in the end. So whatever your situation is, make sure that you discuss it with your probate litigation attorney so you have a realistic expectation at the beginning of your case. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.